We'll take a call and then we'll continue with our section. The caller number ending 0779.
Hi Prashanthi, this is Pallavi.
Hi.
I have a question regarding H1B. On this year, February 2020, I have filed extension and amendment with the client, with one specific client. After that, I got an RFE in the month of April in between, and we have replied to them to the May saying, providing all the required documents and all. My H1B validity ended in August 1st. So far, I have waited for the USCIS, but they did not give any update. So again, my employer has raised a request and asked them to look after my file. Again, on the September 28th, I got an RFE, again one more RFE, asking that to show the status and the proof that I have been maintaining. The thing is, the USCIS has approached to my client. They had given the joining date when on the day where my interview was taken. So USCIS is telling that is a mismatch of dates. So I got an RFE saying make the status, maintaining the status, pay stubs, weekly activity, everything they asked me to provide. But unfortunately, I lost my job due to the pandemic after the RFE has given. So right now, to maintain the status, what should I provide them? Like whether I need to provide the same client details saying I have been worked so far on the same thing, or weekly activities and everything. So because I did not have job right now due to pandemic, I did not got another offer also. Now I am in bench. So how should I respond to them and convey the time sheets or weekly activities, whatever proofs to maintain to them?
So if you have an RFE, second RFE, and depending on what they're asking for, and if you have said in the H1 that your work site is the client site, but you no longer have that work, then I don't know on what basis you're going to respond to the RFE, because the entire H1 has been filed based on work at the end client site, right?
Yes, correct.
So you can't really
So how to respond to that RFE?
You cannot respond. You have to withdraw it because there is no longer work there. So the LCA is no longer valid, which means your H1 is, the H1 petition that you filed is no longer valid. Did you file for a change of status from an F to a H?
No, because the thing is already my H1 validity got expired on August 1st, 2020.
So this is an extension that you filed?
Plus
is this an extension that you filed? Okay. So your I-94 has already expired.
Yes, correct.
So my suggestion is that while this H1 is pending, the only way to do it is delay in responding to the RFE, and while the H1, this RFE is pending, file for another H1. And then hopefully based on the bridging, they will, approve the second H1, or you have to file for a change of status right now to a B2 if you don't have a project, so that you can maintain status. But the only thing you need to prove is that as of the date of filing, the project was there. So my suggestion is immediately, if you don't have a project, then immediately file for a B2. If you have a project, immediately file for a H1 again, based on the receipt, based on the pending application. If you don't have, file for a change of status to a B2 based on the pending application, based on the receipt. And then once you get, a project, then again file a change of status from a B2 to H1, and you're not subject to the cap because you're previously on a H1. And when the time comes to respond to the RFE, remember you have a 60 days grace even after the time. to respond because of COVID. So when the time comes to respond, then you just have to respond saying that the project was, at the time that we filed, it was there, and this is proof to show that when we filed, the case was a bona fide case. But after that, the project got over, and therefore we are not able to provide you with the information that you're requesting. Remember, it's important to show that as of the date of filing, it was a bona fide project, because that will help you with your bridging. When you file the change of status to a B2, they won't say that, it was a frivolous case that you filed, and therefore there is no bridge created. You have to prove that it was not a frivolous case. So that's the best option you have.
Okay, but December 24, 2020 is RFE response date. As there is a
So you
60
can
days grace,
postpone it to 60
I can
days.
wait. Yeah, till February 24th, I can wait.
Right.
So
Until then,
what is the best
before
way?
that, make sure you either file a change of status or, another H1 based on this receipt.
Okay.
A transfer.
Without job, can I do that, or do I
No,
need
you
to
cannot.
get the job and
No,
then
the employer has to be able to show that you have some kind of job for them.
Okay. Sure. Thank you, Prashanthi. Thank you for
You're
your
welcome.
time.
Bye.
Thank you.